Okay, great. Okay, so go to my first slide here, which is just basically the legal foundation of the landlord-tenant relationship. So a few things involved here. So first you have the contract, and the contract is the tenancy agreement between a landlord and tenant. You also have the common law between the landlord and tenant, and the common law is basically whatever court decisions we've gotten along the way related to housing issues. And then we also have the statute. We have the Residential Tenancy Act, and then related statutes such as it's called the Frustrated Contract Act and Manufactured Home Park Act, but mostly we're just often dealing with the Residential Tenancy Act. And then the Residential Tenancy Act also has a set of regulations. And what the regulations do is they provide a standard term that must be included in any tenancy agreement. They also address other things and provide further clarification to what's already in the Act. So if you're trying to figure something out and you're looking at the Residential Tenancy Act, I'll just call it the RTA, and you still feel like there should be more, check to see if it's in the regulation, because you might get further guidance in the regulation. There's also the policy guidelines. The way to access them, you just Google Residential Tenancy Branch Policy Guidelines. They have several guidelines that, again, just provide more clarification on different topics in housing and under the Act. So the policy guideline is another place to go to if you're trying to figure out an issue and figure out what the rights or obligations are of a tenant. Definitely you want to go to start with the Act first, and then maybe check out the regulations and then the Residential Tenancy Branch itself. There's also the Residential Tenancy Branch has a rules of procedure. This is more relevant if you decide to represent a tenant and you've helped them with filing an application and going through the whole dispute resolution process. So the rules on what you need to do for that process will be in this rules of procedure. So those are sort of the main kind of governing things to look at when you're looking at a landlord-tenant relationship. A little more on tenancy agreements. So one thing to note is tenancy can always be reinstated. So if you have a tenant whose, their tenancy is ended, say they went through the residential tenancy branch process, landlord tried to evict them, they weren't successful, but the tenant stayed in the unit and continued, and the landlord continued to accept rent, there could be an argument that the tenancy has actually been reinstated and hasn't actually ended. And to deal with that, you'd want to go file an application with the RTB to have a determination that the tenancy has in fact been reinstated. Some of you might have seen this already. When a landlord is successful in the residential tenancy branch dispute resolution process, they have an order of possession granted, tenant has to get out. If they do agree to allow the tenant to stay there an extra month or two, they might issue rent receipts that say for use and occupancy only, or they'll use these magic words, use and occupancy only, which is supposed to suggest that they still want the tenant out, that they're just collecting the rent for the use and occupancy and they don't have a tenancy agreement. So if you see that, chances are the tenancy has probably not been reinstated, but it's not a definitive question. Just because they use the magic words on a rent receipt doesn't necessarily mean that the rent hasn't been, or the tenancy agreement hasn't been reinstated. There are other things the landlord might do either implicitly or explicitly that would suggest that the tenancy has maybe been reinstated. Also, so Section 5 of the RTA says that parties cannot contract out of the Act. So whatever's in the Act, you can't contract out of it. And the Act does lay out certain rights that tenants have. A landlord can't contract out of that right. They can't say, well, the RTA says you have this right, but I'm going to make you sign something that says that you don't. So they can't circumvent their right, the tenants' rights or their obligations as landlords by trying to get a tenant to contract out and sign this other additional agreement saying that something doesn't apply. A landlord also can't unilaterally change the tenancy agreement without the tenant's consent. Also something that certainly seen often doing housing work is, a tenant will come to you and say, well, the landlord wants to change my tenancy agreement or wants to update my tenancy agreement. What do I do? And the answer is they don't have to sign the new tenancy agreement if they don't want to. If it's less favorable to them, if they want to make sure that the original terms continue, then they don't have to agree to change their tenancy agreement. The one they initially sign is the one that they can stick throughout, and the landlord can't force them to sign any new agreement. But of course, the tenant might decide to, but they have to give their written consent to do that. And always a good idea to compare the two, because you might be signing an agreement that is more favorable or not, but always good to kind of look at the two of them to see which one might be more beneficial. There are 3 circumstances where a landlord can change the terms of a tenancy without the consent of the tenant. One is a rent increase in accordance with Part 3 of the RTA. Part 3 of the RTA tells a landlord when they can actually increase the rent and by how much. So they can just go ahead and do that. They don't need consent from the tenant to raise the rent in accordance with the rent increase provisions of the RTA. They don't need written consent to withdraw or restrict a service or facility, and that's in accordance with Section 27 of the RTA. Just know that if they do withdraw or restrict a service or facility, I don't go into that too deeply in this presentation, but there is a specific process they are supposed to follow when they do that. They can't just cut off a service or facility and that's it. There's a whole process laid out in the RTA as to how they're supposed to do that. And also they don't need written consent from the tenant if there is a term of the tenancy that has to change because they already went through the dispute resolution process and an arbitrator made an order. So an arbitrator may have made an order that, moving forward, this is how this new term will be included in the tenancy. Then written consent is not required from the tenant because you have an arbitrator's order stating that this change will now occur. Also, so a tenancy agreement can be written in verbal. Get this question a lot as well. Some folks feel that because they didn't sign a written tenancy agreement that they might not have one, and that's not true. A tenancy agreement can be verbal. It doesn't always have to be written. If it could be written, that's better because then there's something to refer to. But just because there is no written tenancy agreement doesn't mean that the tenant doesn't have one and the tenant's not under the RTA. They still have all of the rights and protections under the RTA, regardless of whether or not it's written. Also, Section 12 of the RTA says that a landlord has to ensure that there are standard terms kind of in every single tenancy agreement, either written or verbal. So again, if you don't have a written tenancy agreement, these standard terms are implicit. They do still apply. And those standard terms, you can find them in the schedule of the Residential Tenancy Regulation. So if you just Google Residential Tenancy Regulation, there's a table of contents at the bottom. It'll just have schedule, and then it'll take you right to the schedule and lays out all of those standard terms that must always be in a tenancy agreement. Some of these include, the provisions around security deposits, condition inspection, pets, payment of rent increases, assignments, sublets, repairs, occupants, locks, landlord's entry, dispute resolution process, and how a tenancy ends. So these are applicable to all tenancy agreements, regardless of whether or not they're written or verbal. One thing to note is, this is a question that comes up often too, is unfortunately landlords can restrict pets in a tenancy agreement. It's too bad that's not the case in other jurisdictions. Like in Ontario, a landlord can't do that, but here in BC, they still can restrict pets. And they can restrict size, the number, they can put whatever restrictions they want on a pet. The only legal protection right now in place is if the animal is registered pursuant to the Guide Dog and Service Dog Act. So a landlord's not allowed to deny a guide dog team, service dog team, or retired guide or service dog team. But that really only applies to service dogs that are certified as such, which leaves a whole host of other pets and support animals that people need to be with them in their homes. So one other alternative to this is there's always a potential human rights complaint if a landlord is saying, you know, you can't have this service animal, I'm restricting that. There could be a potential human rights complaint to consider. I tried to check to see how those usually go. I looked up past decisions of the Human Rights Tribunal to see what decisions we have where someone has made a human rights complaint for a landlord not accommodating a pet, and there wasn't much, but that doesn't mean that potential is not there. I still think someone can make a human rights complaint if they're not accommodated in being able to have an animal or pet with them. Another thing about tenancies is these fixed term tenancies. Until very recently, landlords could enter into fixed term tenancies with what was called a vacate clause. So these fixed term tenancies would basically just sort of say, okay, you can be here for 4 months, but then after that 4-month period, you have to actually move out. And what was happening was that was being exploited by landlords. They were using them to create these tenancy at wills. They would say, well, they would call them probationary periods. All of that is illegal. You can't have like a probationary period for tenants. You can't see how they're going to be as tenants and then kick them out at the end. If you sign on to a tenancy agreement with a tenant, you can't just say, oh, well, it's only 4 months and then you have to leave. That's changed. So now what happens is you can still enter into a fixed term tenancy agreement with a landlord for a specific period of time. But what the landlords can't do now is have this vacate clause that says that they have to move out at the end. So what happens is once that fixed term expires, the tenancy automatically becomes a month-to-month tenancy. And the landlord, again, cannot require them to move out unless the landlord, there's only one exception right now. I say right now because there might be more to come. Landlords are definitely lobbying to include further exemptions, but right now you can only include a vacate clause if you enter into a fixed term tenancy agreement and the landlord or a close family member plans to move in at the end of the fixed term tenancy. That's the only circumstance that you can require the tenant to move out once the fixed term expires. And family member is defined in the Act, and landlord is also defined in the Act. I'll talk about this a little bit later on, but very important to know that there's the definition section of the Residential Tenancy Act, and in that definition section, you have the definition of who is a landlord. But in this particular section, section 49 of the RTA, which allows for landlords to evict somebody on the basis that they want to move back in, landlord has a completely different definition. And that definition requires that, you know, the landlord has to have no less than half of the full reversionary interest, and holds no less than half of the full reversionary interest. And what reversionary interest is basically that's the kind of interest the landlord has in the property. When they rent out a unit to the tenant, then the tenant has exclusive possession to the unit, but the landlord always retains this reversionary interest, which allows them to reclaim the property once the tenancy ends. So the landlord has to be somebody who doesn't have less than half of that interest in going back. So if there are multiple owners of that particular property, the one who's giving the notice that they want to move in has to have kind of more than half of the ownership of the property. So an important thing to kind of pay attention to. You run into this more with private market landlords, but something I like to highlight for folks, because oftentimes it's easy to kind of look past that definition of landlord because it's already defined elsewhere. Not everyone knows that you have these two different definitions for different purposes. Okay, what the RTA does not apply to. This comes up a lot in the nonprofit housing sector. And so there are some tenancy type situations that are excluded from the Residential Tenancy Act. So the RTA again gives tenants some rights and some obligations, but there are certain kind of accommodations that the RTA does not apply, which means that whatever protections a tenant would have under the RTA for folks who live in an accommodation that the RTA doesn't apply, they don't get those same rights. And not only that, there's no venue like the residential tenancy branch to go and dispute any issues the tenant has with the landlord. So I've listed some of the types of housing accommodations that the RTA doesn't apply. The list is longer than this, but this is the one that comes up most often. So co-ops, RTA does not apply to co-ops. RTA does not apply to living accommodations in which the tenant shares a bathroom or kitchen facilities with the owner of the accommodation. Notice here, owner, not landlord. That's another important distinction because a landlord doesn't necessarily have to be an owner. If you look at the definition of landlord, it's not always owner. However, for this exemption, it actually has to be the owner of the household that you're sharing these facilities with. It also does not apply to emergency shelters, transitional housing, that's the big one. I'm going to get into that a bit more. And housing-based health facilities that provide hospitality, support services, and personal health care, or is made available in the course of providing rehabilitative or therapeutic treatment or services. So that's a long one. What's important to note in this one is there are a few key words to really pay attention to. One is housing-based health facility. So it still has to be some sort of health facility. And they have to not only provide hospitality support services, but they also have to provide personal health care. So they have to be providing both. And why this is important is because historically, and some of you may know this or have encountered this, a lot of nonprofit housing sector, a lot of nonprofit housing providers would claim that the accommodation is outside of the RTA and that the RTA does not apply, which of course is not great for the tenant in that situation because they don't have the rights otherwise afforded to tenants under the RTA, and they don't have that venue, the RTB, to go challenge eviction notices or to dispute any other matter with the landlord or compel the landlord to do repairs and whatnot. So it's not at all in the tenant's advantage to not have the RTA cover their tenancy. But in the nonprofit sector, it is because they can do things the way they like. And that's why they often allege that it's outside of that particular housing accommodation is outside of the RTA because they want to be able to just do things as they please without having to constantly follow what their obligations are under the RTA, which obviously can have horrific, devastating impacts on tenants. So that's been, an ongoing issue for a really long time. Transitional housing used to be the type of accommodation most of the nonprofit housing providers would claim they were when they weren't. So because this was happening ongoing, nonprofit housing sector saying that they were providing transitional housing to people when it wasn't transitional housing, a lot of housing advocates rallied to get a definition of what transitional housing is. So they finally got it, and the definition of transitional housing is in the regulation. It's in section 1. And so for a living accommodation to be transitional housing, it has to meet each of these 3 criteria. They have to meet all of them. So 1 is that it's provided on a temporary basis. So one very evident sign that something is not, that a living accommodation isn't transitional will be that it's not temporary or that the tenant's been there for 5+ years. and there's nothing in place that's going to require them to leave. Usually, if that's the case, it's not transitional. You didn't meet that first criteria. Second is that the living accommodation is provided by a person or organization that receives funding from local government or the government of BC or Canada for the purpose of providing that accommodation. I underlined that because it's not enough that they just receive government funding. The government funding has to be specific for the purposes of providing that accommodation. And if the funding is to provide tenant supports, which I know that a lot of these agreements say, the BC housing agreements with a lot of the nonprofit housing providers just say that they're there to provide tenant supports, then they're not providing that funding specifically for transitional housing. So that's a really important part of that second criteria. And the third is together with programs intended to assist tenants to become better able to live independently. And often, when in the past, whenever I've assisted folks who were in a living accommodation that the landlord alleged was transitional, oftentimes there weren't any supports or programs that were assisting the tenant to live independently at all. There was nothing in place. So oftentimes that third criteria wasn't met either. And even though there might be a transitional housing agreement or program agreement signed, it doesn't mean anything. Like a tenant can sign a program agreement or a transitional housing agreement, and it doesn't matter. If these criteria aren't met, it's not going to be transitional housing and will likely fall under the RTA. We also have a guideline. It's guideline number 46, and it's emergency shelters, transitional housing, and supportive housing. And they give a further definition of transitional housing in this policy guideline. And I underlined a really important part to that as well. So transitional housing is intended to include at least a general plan as to how the person residing in this type of housing will transition to more permanent accommodation. And again, usually that's not happening. Usually there is no transition plan. So that's another key element of when something is actually transitional. So they have to have all of these things in place before they can claim that the housing is transitional. And again, in my experience, most often the nonprofit housing providers who claim to be providing living accommodations that's transitional housing, it most often isn't transitional housing. And it's more closely either independent housing or supportive housing, which are both covered under the RTA. So as I mentioned, transitional housing was sort of the most popular type of living accommodation that the nonprofit sector claimed for certain types of housing. They would often try to argue this is transitional, the RTA doesn't apply. And after the definition of transitional came down, landlords are always really good at finding ways to circumvent the act and circumventing policy. And what they started to do was then claim that they were housing-based health facilities. When claiming their transitional didn't work, this was the next way they tried to claim that the RTA didn't apply. And again, the housing-based health facility, important things to pay attention to. It's a health facility, and it's got to provide both hospitality support services and personal health care. So unfortunately, we don't have a definition of what a housing-based health facility is. We do have a bit of guidance. There is a BC Supreme Court case called PHS Community Services Society and SWAIT. And the judge in that case acknowledges that, there's no definition of housing-based health facility. But the fact that there was an email exchange between an advocate for the residents of this particular building and the regional director for BC Housing, they confirmed that the nonprofit housing provider, in this case it was PHS, operates the facility under the RTA. So those kinds of exchanges can always be helpful to these kinds of arguments. And I think a big problem too is not only is it done deliberately, but sometimes it's done because they just don't know any better. In a nonprofit housing kind of management system, I don't think everyone is always fully trained to understand the differences between all these different types of living accommodations. So, and I've definitely seen that myself, where, you have someone who's in the management level of that nonprofit acknowledging that that housing might be under the RTA, but then, a property manager says the opposite. So there's not, I think that there's a lack of understanding of the differences between these types of housing. So what do you do if the RTA doesn't apply? So cases that fall under the RTA, the RTB is your venue. Usually get before an RTB arbitrator through filing an application with the RTB. And those that don't have to go straight to court, small claims court, BC Supreme Court, or federal court, depending on the type of housing. But as long as it's under the RTB, as long as the housing arrangement is under the RTA, your only route is the RTB. You can't skip it and go to court. You have to go to the RTB. They have exclusive jurisdiction over housing and landlord-tenant relationships. Now, if you're unsure whether or not the case falls under the jurisdiction of the RTB or not, it's better to just file an application with the RTB and get a determination from the RTB. It's much faster. And that's always a question you want to ask yourself first. If you are helping a tenant who says they understand their housing to not fall under the RTA because that's what their landlord told them, I would always explore that. Usually the landlord's understanding is wrong for the reasons I just explained moments ago. So that's always a question. The jurisdictional question isn't resolved until you go and have an arbitrator make that decision. So just because a landlord says the housing doesn't fall under the RTA doesn't mean that that's the case. It's always the first thing to figure out and determine is whether or not that's actually true. And again, in my experience, most often it's not. Most often a landlord will have communicated that the housing is transitional or doesn't fall under the RTA, and then when you look at the relationship and you look at what's actually going on, it most often is not transitional and is, again, either supportive or independent housing. Okay. Yep. And so, so supportive housing is different from transitional housing, and supportive housing is covered by the RTA. Another thing that a lot of nonprofit housing providers don't know, I myself have been around people who work for BC Housing and will say supportive housing does not fall under the RTA. So again, I think it's just a lack of knowledge, a lack of understanding how the law actually works, because supportive housing is absolutely under the RTA. And we also have a definition of supportive housing in Policy Guideline 46. So supportive housing is a long-term or permanent living accommodation for individuals who need support services to live independently. The RTA applies to supportive housing. So very clear, supportive housing is covered by the RTA. So the next little bit I have is just sort of highlighting some of the bigger issues we encounter in the nonprofit housing sector. Guest restrictions is a big one. It's a difficult one because there are some tenants who feel they benefit from building-wide guest restrictions. They feel safer because of building-wide guest restrictions, but then you also have a lot of tenants who feel that the guest restrictions completely diminish their quality of living in that particular building. Some guest restrictions are really egregious, where children aren't able to visit, where family members aren't able to visit, or are only able to visit up till a certain point. So some tenants find it to be very egregious and a complete infringement of their rights. So guest restrictions, according to the RTA itself, basically a landlord isn't able to unreasonably restrict access to the residential property by the tenant or a guest of the tenant. So key there is a landlord can't unreasonably restrict. So what does unreasonably restrict mean? What are the parameters of that? And there has been a lot of case law developed on that. Here we also have the regulation also goes into how the landlord must not stop the tenant from having guests under reasonable circumstances in the rental unit. So it's also in the regulation. And then we have the case law. Some of you may be familiar with this case. This is the big case on guest restrictions. This is the Attira and Richardson case. And basically what this case says is landlords cannot have these blanket building-wide guest restrictions that apply to all tenants. Now, it might be reasonable for a landlord to put a guest restriction on a particular guest of a tenant because that guest disturbed other tenants or caused damage, but they're not allowed to just impose that on everybody and impose these restrictions on every single tenant who lives in the building. So these building-wide blanket policies were found to be unlawful. And that comes from this Attira and Richardson case. And then it was further discussed in that PHS and Swate case again, where the judge in this case confirmed the Attira decision. And this judge said to paragraph 56, I have it underlined, I think she acknowledged something really important where she said, you know, the petitioner, and in this case the petitioner was the landlord, so the landlord had not provided any justification of why tenants who are being given a social benefit of below market housing in an effort to try and stabilize their living situation ought to be given less legal rights than tenants paying market rates in a residential building operated by a commercial entity. So she, you know, made a really important observation because of course this was a nonprofit housing provider that was saying they needed to have these building-wide guest bans in order to manage their building, and they referenced the population of the building, and she was just like, well, just because, you know, you're going to highlight this particular population of the building as, I think they used the term problematic or some terrible term like that, doesn't mean they're not entitled to rights. And so that was, I think, an important observation from her, and it's in the decision as well. And I think in this case, some of the guest restrictions the landlord imposed were requiring government issued ID, and that continues to be a problem as well, because as we know, some folks don't have government issued ID and can't get it or don't want to get it, and if that's the case, they shouldn't be banned from entering a building. So I think that case acknowledged that as well.
I have a question.
Yeah.
I have a friend who just asked. The landlord asked if her boyfriend ever come to her place, is going to charge her additional $20. Is that illegal?
Oh, is it just for a visit? Like they would charge $20 for the boyfriend just to visit?
Yeah, to visit or to stay at her place.
Yeah, to visit, they cannot charge a fee for visiting. If it's somebody who turns into an occupant, so it depends on the tenancy agreement. If someone's just coming to visit for a day or two, no, they probably can't charge for the guests to come. But if in their tenancy agreement, there might be something that addresses occupants, and it might say something like, if you have somebody stay with you for a period of 14 consecutive days, they're going to be an occupant and we're going to charge them, then they can. But it has to be in the tenancy agreement. If there's nothing in the tenancy agreement that that highlights occupants or someone who might come and stay for the longer term, then they can't charge.
Right. They just renewed the contract, and now the landlord said he want to add one more item on it, just like saying that to add the extra charge.
Yeah, and the thing is, the tenant doesn't have to agree to that. If the landlord's saying they now want to add something to the tenancy agreement that says they are going to charge $20 for any guests, or $20 for every guest who stays beyond 14 consecutive days, unless the tenant agrees to that, they don't have to sign it. Because again, a landlord can't change the tenancy agreement on their own. The tenant has to consent to it as well. And there are terms like that could be an unconscionable term. Unconscionable terms are terms that are outside of the RTA that are egregious and unfair. And so even though someone signs a tenancy agreement or signs an addendum, if that term is unconscionable, it doesn't matter that they signed it. If it's deemed unconscionable, it's unenforceable.
Gotcha. All right, thank you.
Yep, you're welcome. Okay, and so that's just a bit about, the nonprofit housing sector and some of the issues that often come up. Wellness checks are another issue that often comes up. I didn't go into it for this presentation, but something to keep an eye on. Similarly, whether or not the landlord's allowed to have these blanket policies that apply to everybody without someone having the option to opt in or opt out, I think are generally going to be found to be unlawful, especially because in the case of wellness checks, the landlord is already allowed to enter the unit if they feel there's an emergency. They have the power to do that anyway. So that's another thing to think about. When are these building-wide policies ever unlawful? And for the most part, they generally are if they're restricting the tenant's rights in some way. The next few slides I have is just really quickly kind of the main issues that, again, you are either encountering most often or have encountered most often. One is quiet enjoyment. Every tenant has a right to quiet enjoyment, and this quiet enjoyment includes things like the right to reasonable privacy. So when a landlord enters the unit without giving proper notice, that's a breach of their quiet enjoyment, because at that point their right to reasonable privacy was violated. Freedom from unreasonable disturbances. They're entitled to exclusive possession. Again, they're the one, when a tenant is renting a unit, they have exclusive possession. The landlord cannot come in whenever they want and do whatever they want. There are protocols, there are ways in which the landlord is able to enter the unit, which I'll go through a little bit later on. And they can use common spaces for reasonable and lawful purposes and free from any significant interference in being able to enjoy the common space. So usually if something's going on and the tenant isn't really able to enjoy their unit for these types of reasons, then the recourse is filing an application with the residential tenancy branch. And normally what tenants ask for in those situations is a rent reduction. So rent reduced by a certain percentage, depending on how long the disturbance had lasted and the extent to which the tenant was disturbed. And maintenance and repairs, another common problem, landlords not completing repairs and landlords accusing tenants of having to do things that tenants aren't supposed to do. That might be a landlord's obligation. So Section 32 and Section 33 of the RTA address the landlord-tenant obligations to repair and maintain the unit. There's also a policy guideline on this, and it's Policy Guideline 1. And generally, the landlord is responsible for ensuring the rental unit and property meets the health and safety and housing standards established by law and are reasonably suitable for occupation given the nature and location of the property. So this is why the landlord has the duty to deal with issues like pest control, because they're the ones who have to ensure that the housing meets the health, safety, and housing standards. So it's always going to be the landlord's obligation to take care of pest control. It only becomes a problem for the tenant when the landlord's accusing the tenant of not letting them know that the pest problem existed, and the landlord may be able to actually evict a tenant on that basis, because by failing to alert the landlord to pests, then those pests could have the issue would not have been resolved. The pest infestation could have spread throughout the building, and then that might put the landlord's property at significant risk. So there's still this obligation for tenants to alert the landlord to the pest problem in their unit, but it's still ultimately the landlord's responsibility to address it. Now, the tenants must maintain reasonable health, cleanliness, and sanitary standards throughout the rental unit or site. So just, keeping the unit clean. Tenants are generally required to pay for repairs when damages are caused by them or their guests. may have seen this too. Maybe a window got broken. The landlord will ask the tenant to pay for the damage, but that sometimes also comes into question. Was the damage actually caused by the tenant? That's not always so clear all the time. And the tenant is not responsible for reasonable wear and tear to the rental unit. So if something is just wearing and tearing and broke, or is completely non-functional because it's so old, that's the landlord's responsibility. That's not the tenant's. And anytime the tenant wants to request a repair, you also want to make sure that the repair is in writing. Everything is about creating the record. You got to always create the record, because you have to anticipate you may have to go to the RTB and you're going to have to show the evidence. So always put the request for repairs in writing. Give them a reasonable time to complete the repair by. And if the landlord doesn't do that, then the next step is filing an application with the RTB for an order compelling the landlord to actually complete the repair. Roommates is another issue that comes up often. So you have co-tenants and you have occupants. That's how the law distinguishes two people who are cohabitating in a unit. So a co-tenant is another tenant in the unit who rents the same rental unit under the same tenancy agreement. So usually they will be named in the tenancy agreement. Again, they don't have to be named. Just because someone is not named in a tenancy agreement does not, again, mean they don't have the tenancy with the landlord. What it comes down to is whether or not that tenant and the landlord have a landlord-like relationship. So, for example, if this other tenant pays their rent directly to the landlord and not the other tenant, then that's more of a landlord-like relationship, and they're more likely a co-tenant, not an occupant. All co-tenants are responsible both as one group and as individuals to comply with the terms of the tenancy agreement. So if rent is, say rent is $1,200 and there are two tenants living in the unit, if one tenant can't come up with their portion of the rent for that month, it's both of the tenants' responsibility. So both tenants can be evicted if the landlord doesn't get their full $1,200 a month. So sometimes, you have a situation where the tenant's upset because their roommate didn't pay their portion of the rent and now they're being evicted, and wonder if they can be evicted even though they paid their portion. Yes, they can be. They're both liable. They're both expected to come up with the amount regardless of who paid what. That's something for the tenants to work out on their own. The landlord just needs to have that full amount, and it's both tenants' responsibilities that they get that amount, regardless of how it's portioned out between the two. Also, this is really troublesome too. If one tenant gives proper notice to end the tenancy ends for everybody. So you have two tenants in the unit. The one tenant's like, I'm going to leave. They give written notice 30 days in advance to the landlord. The tenancy ends for both those tenants, even though the other tenant never signed the notice to end and never agreed. So one tenant can unilaterally end the tenancy for other co-tenants in the unit. Now, the landlord can always decide to enter into another agreement with the remaining co-tenants. And if the landlord accepts money, then there's a question of whether or not the tenancy was reinstated. But one tenant can actually end the tenancy for all tenants, and they must all move out. Now, co-tenants also have all the rights and obligations under the RTA. So again, if someone is a co-tenant, they have the rights under the RTA. If someone is an occupant, they do not. Occupants do not have any rights under the RTA whatsoever. That's why it's always probably in a tenant's best interest to sign on to the tenancy agreement if they can. If someone's moving into a friend's place, the best thing for them would be to sign a tenancy agreement, because if they don't, and they don't have this landlord-like relationship with the landlord, they have zero rights. And they can't go to the RTB, they can be kicked out whenever, and it's a less favorable position. So it's always good to try to get on the tenancy agreement, always in the best interest of the tenant in those situations. If they obviously want to be under the RTA and have those rights. There is a policy guideline on this, and it's policy guideline 13. It explains a bit more. It also provides several scenarios of where, there are co-tenant situations and what happens in this scenario and that scenario. So it's a pretty helpful policy guideline. And I'm just mindful of the time. Only have about 10 minutes, and I have quite a bit more to go. I have a section on evictions and when tenancies end and each type of eviction. And then I also have a little thing on the compliance and enforcement unit and then the COVID stuff.
Okay.
Um, what
Let's
what's
prioritize
best?
evictions, maybe, I think would be the most
Sure.
important thing. Does everyone agree
Okay.
with that?
I agree. Yep.
Yeah,
Okay, excellent. And and again, I'm happy to do this again to go over what we might not be able to go over today as
right.
well.
Yep.
Okay, so the tenancy can end in several ways. One, most common, landlord issues a notice to end tenancy or an eviction notice. Two, the tenancy agreement is a fixed term and the landlord is going to move in at the end of the fixed term. The landlord and tenant agree in writing to end the agreement. That's called a mutual agreement to end tenancy. And just a heads up, we've been hearing this has been going on lately where landlords are actually asking people to sign a mutual agreement to end the tenancy at the same time they're signing their tenancy, which again is a way that landlords have cleverly found to circumvent the fixed term tenancy agreement, the removal of the vacate clause. It in effect does the same thing that the RTAs removed. So what they do is they say, okay, yeah, sign this tenancy agreement, but you're also signing this mutual agreement that you're going to leave 6 months from now. I think those are unlawful. So if you are encountering those, and you're encountering a tenant who said, well, you know, my landlord said I have to leave now because when I sign my tenancy agreement, I also sign this mutual agreement. That I think is unconscionable. And I think that you could definitely take that to the RTB and argue that it's unlawful. That mutual agreement is unconscionable and they took advantage of the tenant in that situation. Another way, the tenant vacates or abandons the rental unit, the tenancy agreement is frustrated. That would be something like the unit was destroyed in a fire and there's no unit anymore, so there's no way for this tenancy to continue. Or the director orders that the tenancy is ended, and or if the tenancy agreement is a sublease agreement, subleases always have an end date because it's a sublease. So there will always be an end date where the tenant has to move out. Okay, and then so part 4 of the RTA sets out how a tenancy may end. And so you have to, so in terms of the notices to end tenancy, in order for them to actually be effective, the landlord has to contain the following. It has to be in the, it has to be properly completed. And in order for it to be properly completed, it has to be signed and dated, has to provide the address of the rental unit, state the effective date of the notice to end, state the grounds for ending the tenancy. That's really important. Often they're, you know, they'll just do the checkbox, but nothing other than the checkbox, and you're not really getting much of a sense of why they've checked off a particular reason, and be in the approved form. If none of this is, if any one of these elements are not completed, then that makes that eviction notice invalid. So I always recommend that when you're helping somebody in the dispute resolution process, say there's already a hearing, you're going to help them through that. Always look at the notice because it might not be properly completed. And if it's not, and you go to a hearing and you tell the RTB arbitrator, look, this doesn't have the effective date or it's not signed, then likely in that case the arbitrator will set it aside and make a decision that that notice is invalid. Now the landlord will be able to, you know, do the note, provide the notice again, complete it properly, and reissue it to the tenant. But the benefit there is you're getting extra time for the tenant. If it's a tenant who needs extra time or needs to move, this would give them that. It's a technicality, yes, but it's a technicality that might give them more time, not result in the tenancy being saved necessarily. The merits of the notice to end will still be dealt with, but it could, you know, you go to a hearing, it's set aside, it's invalid, then the landlord has to reissue, tenant has to reapply, and then you have to wait your however many weeks before you have a hearing again anyway. So it gives extra time, and I think it's important to pay attention to that. Evictions, these are the main causes of eviction that we most often see. There's non-payment of rent, cause, end of employment with the landlord, landlord's use of property, and tenant ceases to qualify for the rental unit. So I'm going to go through each one of those pretty quickly. So eviction for a 10-day notice for non-payment of rent. So this notice, once a tenant gets it for non-payment of rent, they have either 5 days to dispute the notice or to pay the rent. If they pay the rent, the RTA says that that automatically cancels the notice. I would recommend still applying for dispute resolution because I've seen some dishonest landlords in these situations. And even though the tenant has paid, the landlord will say they didn't. And in cases where there's no rent receipts, there's no way for the tenant to prove that they actually paid. And then what the landlord can do is they can apply for a direct request. So if a tenant doesn't pay within the 5 days or file an application to dispute the notice, the landlord can then apply for a process called the direct request process, which isn't a hearing. The tenant does not have the opportunity to speak. The tenant isn't even aware that it's happening. It's basically a written application where the landlord says, this is how much I was owed. I didn't receive this money. This is how I served the tenancy or the eviction notice. And usually that's all the arbitrator needs to grant in favor of the landlord and issue them an order of possession. So this whole process, even if the tenant paid, there's no way of the tenant letting a decision maker know that because of this silly direct request process that the tenant doesn't get to be a part of. And that's only if the 5 days pass. I always recommend when people get a notice to end for non-payment of rent, I always say dispute. Once you get a notice, dispute it. And the reason for that is all of these notices have very specific deadlines for when you are supposed to dispute a notice depending on the type of eviction notice. So if you don't apply for dispute resolution within that time frame, you are presumed to accept that the tenancy ends. And there's not much you can do to save that. It's something that, you know, would be great to get removed from the RTA because it's basically if you don't file within your timeline, you're kind of hooped. The tenant doesn't have much recourse. You can always apply for an extension of time with the RTB if you haven't made your application to cancel an eviction notice within the specific time frame. But unfortunately, your reason has to be extenuating. So, you know, someone saying that they couldn't because, you know, they were in hospital for 2 out of the 5 days, the RTB is going to come back and say, well, you still had 3. Like they are not, it is so hard to get an extension of time. They apply such a high bar for people to get extensions of time. So I always tell people the second you get an eviction notice, first thing you do is dispute it and then deal with it afterwards. Then think through it. Then, you know, see if there's an opportunity to settle with the landlord. At least you've preserved your deadline, because if that deadline passes, you're pretty much hooped. Unless, again, you have a really good reason why you couldn't apply within that time frame. And oftentimes not being able to get to an advocate or not being able to get assistance within that short time frame, the RTB doesn't allow extensions on those kinds of grounds. So I always tell people, dispute it, dispute it, dispute it. First thing you do when you get a notice is dispute it. So it's 12:58. I still have quite a bit to get through. What do you all want to do? I mean, I'm happy. Like my next thing isn't until 2, but I understand you all may need to go. I'm happy to stay until 2 and keep going, or I'm happy to continue the rest of this on another day. Whatever is best for all of you.
If you want to just wrap up the section on evictions, and anyone that can stay on, I can stay on to at least record it. So.
Okay, sure. I can absolutely do that.
And then anyone that has to go can just go, and then I'll share the video once it's done.
And I can, Eris, I can send you the slides too. Like I put a lot of info on all of the slides so folks can reference the relevant provisions and whatnot. So I can also send you my slides as well.
Yeah, I just have to leave. Thank you so much for this. I really appreciate it. I'll finish it because it is recording.
Okay.
Bye, everybody.
Bye.
Bye, Rhonda. I'll watch the recorded video because I gotta finish up some work stuff.
Okay,
Thank you so much.
no problem.
Yeah, but the rest of us will stay on, I think.
Okay. Okay, sounds good. So yeah, the 10-day notice, again, I always tell folks, just dispute it. You're preserving your deadline. That's the most important thing to do. And again, even if you do pay within the 5 days, I think it's good to still have your application and the opportunity to go to a residential tenancy branch dispute resolution hearing. So you can have that opportunity to tell the judge, I paid rent. And that way the landlord can't do anything sneaky. So that's always my advice. Again, another kind of loophole that landlords exploit, and I've seen them exploit it. And so that's why I often give that advice to folks. Dispute it, and if you can pay the 5 days, great. And even if you do pay the 5 days, still plan to appear at your hearing and tell the arbitrator that you've in fact paid, and then that just is over with. It does seem a little excessive, but I think that is the only way to avoid situations where the landlord sneakily goes through the direct request process. Also, so for non-payment of rent, if the tenancy agreement requires the tenant to pay utility charges to the landlord, and the utility charges are unpaid for more than 30 days after the tenant is given a written demand for payment of them, the landlord can treat unpaid utilities as unpaid rent and give a 10-day notice for non-payment of rent. But again, all of those elements have to happen. The tenancy agreement has to require that. If the tenancy agreement doesn't say that the tenant has to pay the utility charges to the landlord, then the landlord cannot claim unpaid utilities as unpaid rent. And the landlord also has to give that written demand for payment as well. So it's only when this entire process occurs that a landlord can claim that the unpaid utilities count as unpaid rent for the purposes of evicting a tenant. Tenants should also never deduct rent without permission from the RTB or a landlord. If permission is granted by the landlord, if the landlord says, fine, you don't have to pay me so much money this month, then just make sure that that is in writing. I always recommend everything in writing because, again, it's all about the record. So if the landlords agree to that, put it in writing. There are 5 situations where a tenant can deduct money from the rent. It's always risky, though. Non-payment of rent is treated by the RTA as a really black and white issue. Either the tenant paid the full amount on time or didn't. So even if the tenant is $2 short, the arbitrator has to grant an order of possession to the landlord. And this is because arbitrators aren't allowed to use discretion. So in these situations, an arbitrator cannot consider the circumstances of why a tenant wasn't able to pay the full amount, and they're not able to consider whether or not it would be fair or unfair to end the tenancy on that ground. It's very clear. If a tenant is short in rent or not on time and hasn't paid by that 5-day grace period, then the arbitrator 100% has to give that order of possession to the landlord, which is completely unfair because, it doesn't matter that the tenant has been a tenant for 25 years in a place and this is the 1 month out of those 25 years they were short because they had some personal matters that made it difficult for them to pay the full amount of rent. There is no mercy in the RTA for these situations. And again, even if the arbitrator wanted to understand and apply a more fair approach to these situations, they can't. They can't actually do that. So that's why, even though there are these 5 situations where a tenant may deduct money from the rent, it's always something that tenants should do very cautiously. So one of those situations where they can deduct rent would be they actually have an arbitrator's decision that allows the deduction. That's not so risky. You have a decision saying you can deduct so much from rent for so many months. So that's not as risky. You have an order that says that. The landlord illegally increases the rent. So earlier I mentioned the rent increase provision. So the landlord's only allowed to increase rent once in a 12-month period and only by a certain amount each year. And they can't increase it by any more. If they want to, they actually have to apply for an additional rent increase and the RTB has to give them permission. But once in a 12-month calendar year, they can increase it by whatever percentage it is that year, and no more than that. And if they do charge more than that, and they haven't received arbitrator's order to do that, they haven't given permission to increase beyond the allowable amount, then the tenant can just continue to pay their normal rent until the landlord does it properly. But again, you always want to make sure that that's very clearly what's going on, because even, like I said, one mistake, because the non-payment of rent provisions are so strict and so black and white, you just want to make sure that that the deduction, that there's evidence to support why the deduction's happening. Or if the landlord overcharged for security or pet damage deposit, landlords are only supposed to charge 50% of rent for each month, 1 month's rent, 50% of 1 month's rent for security deposit, no more than that. So if they do charge that and you pay it and you find out that you overpaid, you can withhold whatever remaining amount from rent for the next month. But again, you want to document and you want to have evidence to support that that's actually what's occurred. And this last one is the landlord, the second last one is the landlord refused the tenant's written request for reimbursement of emergency repairs. So say there was an emergency repair that occurred, the landlord or the tenant tried to contact the landlord and wasn't able to, so they ended up paying for the emergency repairs out of pocket. They can deduct what they paid out of pocket for future rent. But again, the tenant has to make sure that it's an emergency repair. They're not going to do it for regular repairs. It's only applicable to emergency repairs, and they have to first attempt to try to contact the landlord's preferred repair person. So that's the second lesson. And then the last is the tenant has the landlord's written permission allowing the rent reduction. But again, I would say to proceed with caution in all of those situations, because it's so easy to not be successful in a non-payment of rent or issue. Oh, yes, helpful tip. So landlords are required by law to provide rent receipts to tenants when they pay rent in Section 26, Section 2 of the RTA. And because they are required by law, they must issue rent receipts. Should always encourage tenants to ask for the receipts and to put that request in writing. And that request can reference the law and say, you have to provide me with rent receipts. Please ensure that you do that. Because that's really your only record of payment of rent. And I know that a lot of folks have arrangements with landlords where they're not getting a receipt, and there's no real way of documenting rent was paid. If it's paid in cash and it's being slipped through a slot of a door in the property manager's office, there's no real way to ensure that happened, that the rent was provided, or to tell an arbitrator or demonstrate for an arbitrator that rent's been provided, unless the tenant has a witness with them each time. But rent receipts are the best way to avoid a situation where the landlord is alleging rent was not paid when it was. So I definitely always encourage people, if they can, to ask to be provided with rent receipts each month. Landlords are required by law to do that. Then we have the 1 month notice for cause. This is very common type of eviction notice. So this one is a 1 month notice. So this notice, a tenant has 10 days after the date the tenant receives the notice. And depending on how the tenant receives the notice, when that 10-day expires may be different. So if the tenant received the notice in person, it's deemed to be received that same day. So the 10 days starts on that day that the tenant receives it. If the tenant receives it by mail, I believe the deemed service provisions are 5 days after receiving it in the mail. So it would be when the tenant gets it in the mail, it would be 5 days sort of tacked onto that. But there is a policy guideline on that too. It's I believe it's called service or something like that, and it explains how the deemed service provision works. Obviously, you always want to get it in the sooner you can. You don't want that to ever be an issue that you're disputing in a hearing. You want to not have to worry about whether or not the application was in time. So I always tell people to do it as soon as they can, if possible. But depending on how the tenant receives the notice, that will impact the calculation of time. So the notice for cause, the most common reason why the notice for cause are given is, one is the tenant is repeatedly late paying rent, and the magic number there is 3. And that's not in a policy, that's just sort of, I think, like common customary knowledge amongst advocates who do this work, is if they're repeatedly late paying rent, and that the amount of time that needs to happen is 3 times that they are late paying in rent. Twice it doesn't usually do it. 3 times, yes. And also, if there's a lot of time in between the instances where rent was paid late, then the landlord might not be successful, because if someone was late paying rent last year and then late paying this year, and then like 6 months from now, that might not be repeated late payment. That might not meet that threshold for an eviction notice for cause. And the thing is, landlords sometimes will be okay with a late payment of rent a month here or there. And that's why this provision is here. If a landlord wants to evict for the first time a tenant's ever late or short rent, then they can do that. And if landlords allow it, there's a certain point where the RTB acknowledges, okay, you've allowed it a few times, now you're not going to allow it anymore, so we give you this other way to deal with non-payment of rent, and that's this 1 month for repeated late payment. So that's a common one. Tenant or person permitted on the residential property has significantly interfered with or unreasonably disturbed another occupant or landlord of the residential property. I've underlined significantly interfered and unreasonably disturbed. I think those are key qualifying words. It has to be significant interference. It can't just be interference, and it has to be unreasonably disturbed, not just disturbed. And I feel like the RTB has repeatedly failed to pay attention to those qualifying words. You see people get evicted for things like, oh, they scratched the wall. Oh, this tenant says that this other tenant's not very nice to them, and they didn't hold the door open for them. And these are examples that I've seen. And in those situations, the tenants were unsuccessful and basically lost their home because they weren't friendly to other tenants or caused a scratch on the wall. To me, that's not significant. To me, that's not unreasonable. And I think, again, arbitrators tend to forget that this disturbances and interference are qualified, and they have to reach that threshold, or seriously jeopardize the health or safety or lawful interest of the landlord or another occupation. So I think it's important to always highlight that these kinds of interferences and disturbances are qualified. They have to be significant. It's a higher threshold. And I think it's important to remind arbitrators of that, because they tend to just not pay attention or neglect that. The illegal activity, so another one is the tenant or person permitted on the residential property has engaged in illegal activity that has caused or is likely to cause damage to the landlord's property, has adversely affected or is likely to adversely affect the quiet enjoyment of other occupants, and has jeopardized or is likely to jeopardize a lawful right or interest of another occupant of landlord. The illegal activity, for it to be a ground for eviction, the actual illegal activity has to have some impact on the tenancy. So for example, if somebody had robbed a convenience store 2 blocks away and then was charged with that, you can't be evicted for that. The legal activity actually has to impact either the landlord's property or other tenants in the building. And another example, there's a policy guideline on this as well. Another example is, although it may be illegal to use drugs in one's suite, unless it's impacting like the landlord's property or another tenant, and the landlord has to show how that impacts the property or another tenant, they can't be evicted for that. So just engaging in illegal activity is not enough. and just engaging in illegal activity in your unit is not enough. It actually has to impact other tenants or the property in some way. End of employment, don't see this one too often, but sometimes part of an employment contract with a landlord, like if it's a caretaker or some sort of on-site employee, sometimes part of that contract is the living accommodation, and once that contract ends, so does the living accommodation, so there is an eviction notice for that. Don't see this one too often. Then we have the 2-month notice to end tenancy for landlord's use, and this one, a tenant can dispute the notice has to dispute the notice within 15 days after the date they received the notice. Landlord's use of property applies when the landlord is going to move in or have a close family member move in, and close family member includes the landlord's parent, spouse, or child, or the parent or child of that individual's spouse. Or if the landlord's going to sell the property and the new owner or a close family member of the new owner will live in the rental unit. Oftentimes people think just the sale itself will result in an eviction, and that's not the case. If a landlord sells a building or sells a home, the tenant only has to vacate if the new buyer actually intends to move in on their own, or a close family member of them tends to move in. But if they just want to rent it out, then that tenant gets to stay. Okay, 2-month notice to end because tenant no longer qualifies for the subsidized housing. So tenant 15 days to dispute this notice, and a public housing body acting as a landlord may serve a 2-month notice to end tenancy if the tenant no longer qualifies for subsidized rental unit. And the tenancy agreement must clearly say that the tenancy is going to end if the tenant no longer qualifies for the subsidy. If the tenancy agreement does not say that, then they can't evict the tenant. The tenancy agreement has to specifically say that if someone no longer qualifies for the subsidy, then they will be evicted. If it doesn't, if it's silent, if the tenancy agreement is silent on that, and a tenant loses their subsidy, the tenant, if they can pay the market rent for that unit, again, they can stay. But I think, even though although the tenancy agreement may not state that the tenancy will end if the tenant no longer qualifies for the subsidy, the landlord, may be able to charge market rent. And in that case, the tenant may not be able to afford that. And then in that instance, the landlord can give them a notice to end for non-payment of rent. But they can't necessarily just say, you don't qualify for the subsidy anymore, you're going to be evicted, unless the tenancy agreement explicitly says that's going to happen. And then we have the 4-month notice to end for demoviction, renoviction, repair, or conversion. And I'm sure you all know that this type of eviction has undergone some changes in the last little while. It's still very strict. It's still not ideal, not even close to being ideal for tenants, but there have been some changes. One of those changes is that the tenant now has 30 days to dispute a 4-month notice. It used to be a 2-month notice. So they used to only have 15 days, but now they've stretched it out to be a 4-month notice to end, and now tenants have 30 days after the date they receive the notice to dispute the notice to end. They also get 1 month rent for free, and a landlord may end the tenancy to renovate, demolish, or convert the property. But because of recent case law, the Bauman case, we have a little more guidance from the courts on this. Basically, a landlord, and then from that case, a lot of what the judge found, both at the Supreme Court case and the Court of Appeal case, it was appealed. The tenant was successful at the BC Supreme Court case, and then the landlord appealed it to the Court of Appeal. The tenant was still successful, but the law became more narrow. The BC Supreme Court decision was a good one. It was really favorable, but then once it was appealed up to the Court of Appeal, a lot of those gains made at the Supreme Court level became more restricted. But in any event, all of that was kind of entrenched into the policy guidelines. So a landlord has to act in good faith if they plan to end a tenancy to do major construction or major renovations or repairs. That means the landlord has to have an honest intention and no ulterior motive to take advantage of a situation. The landlord must honestly intend to use the rental site for the purposes stated on the notice to end the tenancy. And when the issue of an ulterior motive for an eviction notice is raised, the onus is on the landlord to establish they are acting in good faith. Arbitrators get this one wrong often. All that needs to happen, in my opinion, in these types of situations is you just need a tenant to say, I don't think they are going to renovate the unit, or their motivation is to get me out so they can charge triple the amount of rent. All the tenant has to do is raise that this is not a good faith eviction, and once they do that, then the landlord has to prove that they are going to do what they plan to do. And some more helpful information that's in the guideline. The BC Supreme Court, in a case called Barry and Clowett, the BC Supreme Court found that the renovations by their nature must be so extensive as to require the rental unit to be vacant in order for them to be carried out. So a landlord can't end the tenancy for cosmetic renovations or cosmetic repairs. If the landlord is working on the bathroom or the kitchen and the unit doesn't need to be vacant for the work to be done, can end the tenancy for that reason. And that's what these cases often come back to. It's, does the tenancy actually need to end for this to happen? Can you do the repairs and renovations with the tenant still there and their belongings still there? And if the answer is yes, then the tenancy shouldn't be ending. Now tenants have a right of first refusal. I unfortunately, it's not, tenant advocates have been asking for this for a long time, and the RTB has not provided it in a way that reflects what tenant advocates have been asking. So right of first refusal, the way tenant advocates have been advocating for it, would be, okay, say if someone's evicted, once the renovations are completed, the tenant who lived there should be given the first opportunity to move back at the same rent they were paying before they moved. So tying the rent to the unit, not the person. And so that would have been the ideal situation. Okay, you need to renovate, I'll move out. But when I come back to the renovated unit, I'm paying the same amount of rent I was paying when I moved out. That's not what happened. The RTB's version of the right of first refusal, unfortunately, is basically like, okay, yes, the tenant has the first opportunity to come back into their unit once it's renovated, but the landlord does not have to. The landlord can increase rent to whatever they want. And so the question becomes, who's actually going to be exercising that? Who's going to be in a position to come back and pay triple the amount of rent once the unit's renovated? Not many people. So it's kind of an empty, substanceless kind of provision that they think is beneficial to tenants, but it's not. Because again, who's really going to be able to come back to the unit and pay triple the amount or more? There are no limitations. The landlord can charge whatever they want. The only benefit the tenant gets is, rather than being able to end the tenancy and re-rent to whoever they want, they get the first opportunity. The initial tenant, the tenant who vacated, gets the first opportunity. But what does that matter if the rent is completely unaffordable? So it's just because they use the term right of first refusal does not mean that has any substance or any benefit to tenants whatsoever, which was unfortunate. And then we have tenants' compensation. So if the landlord evicts, if a landlord evicts a tenant for landlord's use, either for the purposes of moving in themselves or having have a family member move in, if the tenant discovers that the landlord didn't actually do what they said they were going to do, so if the tenant was evicted because a family member was moving in, and then a month later they see the unit for rent, they can apply for dispute resolution, and they will be entitled to 12 months rent payable under the initial tenancy agreement. So whatever they were paying in rent, they're entitled to 12 months of that if it's discovered that the landlord evicted them in bad faith. So the landlord, if they don't take steps to accomplish the stated purpose for ending the tenancy within a reasonable period, or use the rental unit for that stated purpose for at least 6 months, beginning within a reasonable period. So, and the tough part is always how do you get evidence of this, but oftentimes tenants who know that they'd be entitled to this pay attention and try to see if the unit's been placed back on the market, because they're going to get their 12 months if they can show that the landlord did not use the unit for the stated purpose they said they would in order to end the tenancy with that tenant. Now, there is an exception, so the landlords won't have to pay the 12 months if there are extenuating circumstances, but examples of these extenuating circumstances are things like, you said your family member was moving in and then they passed away. So that's an extenuating circumstance because that was out of your control. So those are the kinds of exceptions for landlords having to pay this 12 months rent. But again, it seems like that's a pretty high standard. So tenants should be able to get that 12 months rent as long as they can prove that the landlord didn't use the unit for the stated purpose. That's basically all I have on evictions. The rest of what I have is the RTB dispute resolution process. There's an expedited hearing process as well. The reconsideration process, and then I have some tips on just effective advocacy, and then I have all this stuff on COVID. So again, happy to continue, but
just because it's 1:30 now, we can just stop there and then schedule another session to cover the rest of it in another week or two.
Yeah, that works for me.